Professor Manjula Batra, I welcome you for this playlist relating to nurturing smart teachers. And in that, I'm happy that you agreed to speak on law of torts, about which you have tremendous experience, long experience. My first question is, what is the relevance of this subject? Why has it been included in the law curriculum?
Yeah, first of all, I'd like to thank you for inviting me
Okay.
here, and I wish you all the best for this platform. I think it's a very
Thank
good
you.
project that
Yes.
you've undertaken. Law of torts is an extremely relevant subject, and because it tells us how to be civil with each other, it tells us how to treat each other, it tells us how to move in the society, how to grow in the society, develop in the society, because it is a wrong, a civil wrong. For example, if somebody gives you a punch on the nose, okay, you can't move under law of contract. You can't move under any other law or breach of trust. You can only move under law of tort for the damage that is caused to you, harm that is caused to you, maybe physically or mentally. And it is actually regulating the financial losses, the harm that is caused to a person. And law of tort is a very important tool for that. And it is relevant because it is interconnected indirectly or directly with other subjects also. For example, you'll find law of tort now, the application of the compensation bit in all environmental law cases. And it is growing over a period of time. But unfortunately, in our country, we've seen that tort is still at the infant stage. Whereas if you take into account UK or USA, Australia, everybody is aware of a civil wrong that is committed against the person, which may not be a contractual wrong or a breach of trust or a crime.
Okay. Uh, One aspect you have already brought out, compensatory justice. Now, what would you advise the young faculty that they should explain to the students about the goals of law of torts?
See, the goals of law of tort is to get justice, okay, and to get compensation for the wrong or the harm that has been caused to a person, either through medical negligence or through an accident or through any other incident. So the goal is to, again I said, restorative justice, to restore the person to some kind of a strong position. Of course, if you lose a dear one in an accident victim or accident, then you cannot get him back, but at least you'll get compensation because that person is gone, and maybe he was a bread earner for the family. At least you can get money compensation through insurance or under the Motor Vehicles Act, or under causing pain, suffering, mental anguish, all that.
As of now, this subject is taught invariably in the first year, be it a 5-year curriculum or a 3-year curriculum. What would you tell the law teachers that they should explain that this is needed at the initial stage? What's the rationale for that?
Yeah, I'll tell all the new teachers that law of tort has always been introduced as one of the first subjects in the first semester if you have a 3-year degree course on law, and first semester also if you have a 5-year degree course on law. This is so because tort is relatively easier, and yes, it may be technical at times, and it's more interesting than other subjects. When a person comes, especially after school, he's barely 17 or 18 years of age, he will actually not know what's a civil wrong or what's a tort. And for him, learning and being educated through case law, because mostly it is full of case law. And for the students, it is important to understand what is codified law and what is uncodified law. So codified law we find in statutes, and tort law is largely uncodified. It is a product of common law, which we say judicial decisions. And in India, we don't have any statute which governs tort law as such. But yes, we find essence of tort law under Motor Vehicles Act, under Consumer Protection Act, under the Protection of Women from Domestic Violence Act, and certain other legislations now. So it is very interesting for the student to know what is taught because it is very simple, and they find that they can read through interesting cases and build their lawyering skills.
What would your advice would be to the fresh teachers How should the first step be taken? How should the subject be initiated to the students?
Yeah, when it's a new teacher and she's got a subject or he's got a subject to teach as law of torts, it's important for the person or for the teacher to go through all the topics which are there on law of torts. Just go through them breathwise, but not deeply, because deeply the new teacher can find such things later, because he or she has to understand what law of tort actually is, because the duty concept, breach of duty resulting in damage to the concerned person, all that has to be understood. And later on, after teaching a few subjects, maybe the teacher can zero down on a particular area that she or he wants to further carry on research or teach, go into it deeply.
If it is a 5 credit course, what would be your advice? How should the entire module be divided into, say, different modules? How should the entire curriculum be divided into modules?
See, having had the experience of teaching law of torts for years now at the
Okay,
Faculty of Law, Jamia Milia Islamia, I feel that law of torts should be divided into two papers,
okay,
tort 1, tort 2. And tort 1, each paper can be divided into 5 units. And unit wise, you have the modules, you have the
okay,
topics.
okay,
And when you talk about the topics, then you have to explain the doctrines, the principles, you know like we talk about absolute liability, we talk about strict liability, we talk about negligence torts, we talk about intentional torts. So negligent torts, or things like strict liability, defamation, general exception should be in paper 1, of course, along with the remedies. Because what are the remedies for
yes,
torts, and especially remoteness of damages, I feel should be taught in part 1, or you can say taught 1, because how, to what extent should a person be held liable for his tortious act? It
okay,
cannot be infinite. There has to be a line
yes,
drawn, and line drawn on which basis? Reasonable foreseeability, reasonable foresight, and the paying capacity of the person. Because now law of tort, generally what happens is that you're distributing the costs on the society, like we have insurance policies, like we have
okay,
Public Liability Insurance Act.
yes,
Whenever there is an accident in a hazardous enterprise, so there is a Public Liability Insurance that happens. So it becomes easier for the polluter, or for the offender, or for the tort feeser, we call it, for the
okay.
tort feeser to pay. Yeah.
Of course, we have already covered this, but I would, for the sake of clarity, request you to state what are the basic topics that need to be sort of covered and focused upon in the entire curriculum.
See, I think the first topic should be what is tort,
Yes.
that we've derived it from common law and from the Latin word tortum. All that needs to be explained. What are the essentials of law of tort? That needs to be explained on the basis of malfeasance, misfeasance, non-feasance. And after going from the essentials, then we go to why do we call it law of tort, or why do we call it law of torts? That is
Okay.
important. Both schools of thought are prevailing, they're existing, but the student should know the difference. And then, of course, when we talk about Latin maxims, because there is a lot of use of Latin maxims in law
Okay.
of tort. Like I'll say, there is a maxim called ubi jes ibi remedium, which means where there is a right, there is a remedy.
Yes.
So here, it doesn't matter if it is not written in any statute book that there is a violation of your right and you cannot go to the court. As long as the remedy is available and your right has been hurt, you are harmed, you can move to the court. We have examples of the Bhopal case, we have examples of the oleum gas leakage case, and now, of course, we have the example of the Morbi bridge collapse
Yes.
case.
Yes. Thank you that we come to the end of part 1 and we
Okay.
move to